Hey, this is Ryan Witt. I'm a defense attorney here in Washington State. This video is about what happens at your arraignment for the charge of DUI. So if that subject is of interest to you, stick around. Getting arrested for the crime of DUI and everything that flows right after that is really stressful, especially for a person who's never been through this process before. So the purpose of this video is to let you know what to expect at your arraignment, and at least if you know what's going to happen, I think that can bring the stress level down a little bit. So really there are 7 things that happen at your arraignment, okay? Number 1 is you will be informed of the charges. And they inform you of the charges through what's called, it's a written document called a criminal complaint. And it tells you what the charge is. If it's a DUI, it'll say, you're charged with the crime of DUI on such and such a date in such and such county. Also kind of under the umbrella of DUI is physical control. Very similar, they kind of morph together almost. Now, on top of just DUI, there are special allegations that can be attached to the DUI. It could say a DUI plus a special allegation of you refused, or it could be that you blew over a .15, or it could be that you have a child under 16 or multiple children in the car. Those are what are called special allegations, and in essence, it's really a sentencing enhancement. So the point is you don't have to agree with it, but you at least have to be aware of what you are charged with. And the other part of the reason for the written document is they want to make sure your name is correct and that your date of birth is correct. And that ensures that the court isn't creating an alias for you. So that is just being informed of the charges. Number 2 is the judge will ensure to inform you of what your rights are. So you have very important rights that begin at your arraignment and follow all the way through the criminal charge. And kind of a subset of informing you of your rights is, we'll call this number 3 though, it's making sure you have counsel. You'll either show up at court with your attorney, they may be with you, they may be on Zoom, and if not, they'll go through a little colloquy with you of whether or not you'd like to be appointed a public defender. Some people want to represent themselves. I would not suggest that, but you'll either be there with your own attorney that you've hired prior to the arraignment, or you could say, I'm going to hire one in the future, I suppose. Or sometimes the court will say, okay, we're going to go through this questionnaire. We'll see if you qualify for public defense, or they may send you down to the clerk's office to do that, run through some questions, come back. But basically, they want to make sure you've got an attorney and you have good representation going forward. Number 4 is what you do, and really big deal at the arraignment, is entering a plea. 99% of the time at your arraignment for DUI, it's going to be a plea of not guilty. The judges will almost never take a plea of guilty. You would have to do that and convince the court you're doing that with a real sufficient, I guess, a really motivating reason, and you're doing it on the advice of counsel. Because by entering a plea of guilty at your arraignment, you're giving up all your rights and all your appeal rights in the future. So there are very limited reasons to do it. It can happen, but like I said, 99% of the time, you're just entering a plea of not guilty, and your attorney will help you with all that. And in fact, your attorney is going to do 99% of the speaking for you. The court at the complaint stage may ask you your name just to ensure that the spelling is correct and that you are who you say you are, but that's about it. The attorney is going to do all the talking, including entry of the not guilty plea. Number 5 would be setting bail or bond. The police officer may have arrested you and say, okay, come back to court on the next judicial day. A lot of times that's a Monday, and the court will determine whether or not bail should be imposed. Or you could have been booked into jail and you bailed out with the help of a friend or loved one, and you're appearing the next day. And the court doesn't have to necessarily stay with what that officer's suggestion of bail was. Like, if your bail that you bailed out on was $5,000 and the court determines, well, this dude, the cop didn't know about it, but he's got 3 prior DUIs from Vegas, they could change your bail from $5,000 to $75,000. So, they're setting bail. But a lot of times if you appear with an attorney and you have a little bit of lead time, you can work through these issues to put yourself really in the light, the best light in front of the court to make it appear as though and really demonstrate that you're taking this seriously and you're not a risk to the community and you're not a risk to fail to appear. So that a lot of times bail will either be PR, which means personal recognizance, or they just leave it be. If you bailed out and it was, for example, $5,000, maybe they leave it at 5, and then we come to the next thing, which would be scheduling. They're going to tell you to make all future court dates. Some courts will say your pretrial is, X date, about 30 days out. And they'll just say, make sure you come to your pretrial, stay in good contact with your defense attorney, on and on. So that's nice, simple, one date. You have to remember pretrial. Other courts sometimes will set like 3 dates. They'll set you a pretrial hearing, but at the same time, they're going to set you a jury trial readiness hearing and then a jury trial date. And that's really overwhelming for some people. They're like, oh my gosh, why am I going to trial? I hardly set foot in the courtroom. I got one toe wet and we're talking about trial. Really, all those hearings are for as placeholders. I think during COVID, a lot of times there was a propensity, not by us, but some firms to like schedule a hearing and then out another hearing, You get 16 months into these things. So some courts have taken the hard reaction to just set that jury trial. It forces things to happen much more quickly and get people kind of back to how things were pre-COVID. And the last thing, number 7, and I'd argue probably the most important, is the court's going to set conditions of release. So if it's a DUI, the standard conditions would be don't possess any alcohol, marijuana, non-prescribed drug, obviously don't drive while impaired, don't refuse to take a breath test if reasonably requested by a law enforcement officer, don't commit any crimes. If you change your address or phone information, update that with the court. That's what you would hear some people call the standard DUI conditions. But if we go back to number 1, when I was talking about the criminal complaint and special allegations, which are like the sentencing enhancements, the courts get real touchy if the person, the allegation is you blow over a 1.5 or you refuse or there's an accident. You drove up on the guardrail and go over and put your car into the bay. That's a big deal. With all these things, there's going to be elevated conditions of release beyond just what I call the standard DUI conditions. Some courts will tell you you got to put on an alcohol sensing monitor, which is a real pain. A lot of times, if you're in that realm of over a 1.5 or refusal, the court's going to say, and it's not a punishment necessarily, but it's a condition of release. They'll say, you have to install an ignition interlock in your vehicle. Some courts will make you go check in with probation and they'll make you do random urinalysis tests. So, there's things definitely above that standard DUI condition where if you've got a little bit of lead time, like I was saying, you can consult with, your attorney, us, whoever it is over the weekend and talk about, should I put the ignition interlock in now? Should I go do a defensive driving class real quickly? Should I schedule an assessment or a victim's impact panel? All these things that you can present to the court at your arraignment so they don't have to treat you like your public enemy number 1. You can kind of quell everyone's concerns that you're going to go out and be a risk to the community. So that's kind of a quick summary of the 7 things that are going to happen at your arraignment for your upcoming DUI. If you have any questions about this, call a local attorney. If you're, somewhere on the western side of the state of Washington, obviously feel free to call us. We answer ideally 24 hours a day, and hopefully this has brought your stress level down a little bit, and it'll make it a little easier to walk into that courtroom for your DUI arraignment. Now, we really enjoy doing videos like this. I like getting the content out there. If you have a question related to this topic or anything DUI related, I suppose, go ahead and drop it in the comments. We'll do our best to answer it there. Or, if it's something somebody frequently asks about, we'll just do our own video. We'll do another video to answer that question for you. So if you like this, please hit like and subscribe, and thank you for watching.